everybody's come in?
It's
Thank
already
you.
nearly 70 now. I think you can start.
Okay. Good evening from India, and a very warm welcome to all of you who have joined us from different time zones at this 8th virtual lecture series organized by Nivaran. I'm extremely pleased to inform you that our distinguished speaker is Mr. Joel Kriege from South Africa, who will be talking about community mediation in South Africa. I am your host, Shireen Khajuria, and I am joined by your co-host, Mr. Jamshed Bey. Both of us are practicing advocates for the last 30 years at the Supreme Court of India, and we both are also mediators. Mr. Bey will give the closing remarks, while I will introduce the speaker and the topic. This 9th lecture is part of an ongoing series organized by Nivaran, a group of mediators of the Supreme Court of India for continuous mediation education. The first lecture was in a physical setting early last year, but we had to quickly move on to the online mode, which in fact I think has helped connect more of us across various Commonwealth countries. Besides these lecture series, Nivaran, along with the Commonwealth Lawyers Association and the Youth Bar Association mediation seminars. I'm happy to share with you that these webinars have received a very high viewership and a positive response from across the world, because they are not only educative and informative, but it is also a continuous means of knowledge sharing and growth in the field of mediation. We will have a small question and answer session on today's topic after the talk by our distinguished speaker and before my co-host Jamshed's closing remarks. During the talks, the participants can send us their questions for Mr. Joel Kriege through the chat box, and he will take them up one by one soon after his talk is over. It is now my pleasure to introduce to you our distinguished speaker, Mr. Joel Kriege, whose association with India, in fact, goes back to 1991. He visited the Honorable Supreme Court at that time. His visit to India culminated, in fact, in an insightful article on reservations for the underprivileged in India. The seed for the present talk was sown when Mr. Kriege attended virtually one of the first webinars organized by Nivaran, and he ended up having long discussions with Mr. Santhanam Krishnan, one of the founders of Nivaran, who requested him to share his knowledge and experience with us. And that is how we are lucky to have him with us today. Thank you. Mr. Joel Kriege is a well-established advocate and a mediator in Cape Town, practicing at the bar since 1984 as a human rights lawyer. He is passionate about restitution law based upon racially discriminatory practices and anti-apartheid movement, especially related to labor and land rights. He has contributed to establishing labor law and principles on land reform for labor communities in South Africa. He also defended death penalty cases under the apartheid. It's interesting that he has 29 reported cases in the South African law reports, and he has had the privilege of appearing in the Supreme Court of Appeal and the Constitutional Court of Africa. His call for forging new remedies and an examination of the frontier wars of dispossession in the Eastern Cape have been appreciated by the courts in Africa. He is also an honorary legal advisor at the Association for the Physically Disabled and a trustee for Springboks Charity Fund. Mr. Joel Kriege is truly multifaceted, being an avid cricket player, with which we have a connect in any case, and having to his credit not only published works on law, but also on tenets and 2 books on poetry. I would like to quote him. Tennis fills us with endorphins, enabling us to relax under pressure and work late into the night. I'm sure most of us can relate to it, even if we don't play tennis. Before I request our distinguished speaker to speak on community mediation in South Africa, can I share a few of my thoughts on community mediation? Community mediation is a constructive process to assist people, communities, and organizations to resolve their conflict through negotiation, which is facilitated by influential people, elders, NGOs, and trained mediator volunteers rather than through courts. This holds value as it not only empowers the people to resolve their own disputes before it escalates, but also from the point of view of access to justice. Community mediation, as we understand in the modern sense in India, is at a nascent stage. And it may be the topic of discussion on another occasion if we so choose to take it up. But I would like to share just one success story of community mediation in India. Earlier this month, 174 villages in the state of Madhya Pradesh in central India have been declared completely litigation free. This has been because of the efforts at community mediation by the Legal Services Authority of the High Court of Madhya Pradesh. Culture is a very important factor in community mediation. Edward Hall, in his book called The Silent Language, talks about high context culture and low context culture countries. The high context countries are more hierarchical and relationship oriented, with focus on the silent language. That is the context, the body language, and the tone rather than mere verbal language. On the other hand, the low context countries are more individualistic and they rely upon explicit words rather than the context. These characteristics, as described by Edward Hall of the two types of cultures, seem to have a lot to do with the hot and the cold climates of the country. The hot climate countries are usually high context, while the cold climate countries are usually low context. I'm sure you wonder why. Well, as the story goes, please don't hold me to it. This is possibly because of the historical survival needs. In cold countries, people sat around their individual home fires to stay warm, while in the hot countries, people sat around in large community groups. Viewed from that perspective, I believe that South Africa is primarily a high context culture like India and the Caribbean, while the UK and Canada are low context countries. This concept has in fact been more recently applied and further developed by the social psychologist Gert Hofstede in his theory of 6 dimensions of culture, which help distinguish one culture from another. These dimensions are power distance, or the boss culture as more commonly known, I guess, individualism versus collectivism, masculinity versus femininity, uncertainty or risk avoidance, and long-term versus short-term orientation. The most recent addition to this distinction of his has been restraint versus indulgence, where they believe that the high context countries are more restrained. Understanding the difference in culture can avoid misunderstanding in communication. It is in this context that I believe we will be learning a lot from our distinguished speaker's experience today. May I now request Mr. Joel Krige to share with us about community mediation in South Africa.
Yes, thank you, Shireen, and good afternoon, friends and colleagues. Thank you for attending this webinar. It is indeed a privilege to be invited to give my experiences in South Africa. And I'm also particularly indebted to Sansan, who invited me and whose idea it was. I will follow a roughly chronological order, beginning at the beginning of the commencement of formal mediation in South Africa in the 1980s, and talk a little bit about how we were trained, by whom, and then I will present cases that demonstrate the techniques and practices of conducting a mediation. Within a year of joining the bar in 1984, South Africa was plunged into 5 successive states of emergency that continued until the release of Mandela from prison in 1990. The apartheid nationalist government intensified repression, increasing surveillance and police action and detentions in a bid to quell mounting resistance. Developed in this context, partly as a means of resolving local disputes and avoiding confrontation that might lead to intervention by the state. The notion of community mediation was broadly conceived and encompassed a range of organizations and institutions of the disenfranchised. My first mediation came when I was briefed by the Food and Allied Workers Union, formerly the Food and Canning Workers Union, one of two mediators in a wage negotiation in the export apple packing industry of the Western Cape. Under negotiations, the export apple packing industry of the Western Cape and their wages were determined statutorily and gazetted. The Canning Workers Union had a long history as a radical union, starting in the 1940s by Solly Sachs, the father of Judge L.B. Sachs. Much of the fruit, and indeed most agricultural produce, was sold to state-run cooperatives that were regulated under the Cooperatives Act. 3 cooperatives in the Western Cape covered the packing and cold storage industry. 2 were in the mountainous regions of Ceres and Elgin, and the other in the Wellington Power packing area, not far from Cape Town. The mediation was set down for 2 days. The venue selected by the employers was the Ritz Hotel in Sea Point, a very fancy hotel at the time with a revolving restaurant on the roof. Union representatives and the shop stewards from the various cooperatives were all accommodated at the hotel and paid for by the cooperative. The mediator for the cooperatives was a professor from Stellenbosch University's Graduate School of Business, where he taught mediation to businessmen. As mediator for the union, I was fortunate to have secured a copy of the co-op's financial statements through the union's researcher, Debbie Budlander, an activist who had been at university with me and served a banning order for her work in support of the union movement. She was the analyst for the union. Because they were statutorily published, the union could not preclude us from seeing them. The financial statements talk to a larger picture. David Rockefeller, the chairman of a big financial house in New York City, with substantial investments in South African gold and diamond industries, had provided the national government with loans. He came under pressure from the disinvestment lobby and withdrew the loans in 1984. The rand-dollar exchange rate plunged from 1 rand to the dollar to 5 rand to the dollar. The sudden exchange rate was good for South African exports, and the apple cooperatives enjoyed sudden windfall profits. The unions wanted a proper share for the workers. The mediation carried on for the day, and the hotel bar was open. I had no control over the arrangement, and in the evening, the workers' representatives enjoyed a big party. While they partied, the professor and I worked out a fair settlement to present to the parties the next morning. But when the workers came in, they were not interested in discussing it. All they wanted to know is, where do we sign? The big lesson was that alcohol should not be served during the mediation. At this time, the Independent Mediation Service of South Africa, IMSA, started in an office with 1 person and a secretary in Johannesburg. They brought out mediation practitioners and teachers from the United Kingdom and the USA for purposes of training our local mediators. One of these teachers had an indelible impact on me, Arnold Jack, and if I could ask Rahul to maybe put his picture up, whom I believe is 90 years old and still healthy and living in Boston. He was a great raconteur and a teacher of dispute resolution. From him, I learned the foundation principle of mediation, that the task of the mediator is to use intuition and find the key that unlocks the problem. I will illustrate how this principle can be applied later on. There we have Arnold Jack on the right-hand side with Charles Rupin next to him, and second from the left, Cyril Ramaphosa. I will return to them. Arnold Jack's father had been an arbitrator and mediator in Washington, D.C. during the Second World War. Mediation was required because the government had outlawed strikes in the armaments factories for the duration of the war. Ford had been granted a contract to build Sherman tanks. I believe 42,000 tanks were built with Ford motor engines, and General Motors had been awarded the Jeep contracts. By federal law, all disputes had to go to compulsory arbitration. Arnold Jack followed his father's footsteps into labor mediation as a federal arbitrator and mediator. And many years later, he acted as a mediator in the sports baseball industry in America. The core text of our training with Arnold Jack and others was a book called Getting to Yes, Negotiating an Agreement Without Giving In by Roger Fisher and William Ury, Random House, 1981. The book is a classic text in mediation and became an international bestseller. And the second edition is freely available on the internet. Fisher and Ury set out what they believed are four basic principles of mediation. One, the mediation process should not bargain over positions, but become focused on interests. Two, the mediation process should, two, separate the problem from the people, invent options for mutual gain, and insist on using objective criteria. I interpolate here, these pictures that we're showing come from the IMSA National Review of 1995. Getting back to Fisher and Ury, on these four principles, they built a theory of dispute resolution and mediation applicable to a wide range of contexts. Beginning in the 1980s, they became embedded in South African mediation practice, in particular, labor and political arenas. Black workers had recognized that while they did not have the vote, they held enormous power in the ability to withhold their labor. Unionization under apartheid began properly in 1973 with the Durban strikes and continued through the riots of 1976, culminating in labor reform introducing the industrial court and the concept of an unfair labor practice. As in other industries, mining industry in the late 1980s was a site of struggle. At the time, the Mine Workers Union had over 500,000 members and an acutely sharp general secretary in Cyril Ramaphosa, whose picture you can put up again, please. He was reputed to be the only person who could make the Chamber of Mines, the titans of industry, shake in their boots. The Chamber feared that if the union called the workers out on strike, investors from New York and elsewhere would immediately jump on them and tell them to settle the strike to save their profits. In a classic mediation, three rooms are needed. The mediator has his own office to draw and consider proposals and draft a settlement, and the parties their own closed consultation rooms. On one occasion, a wage negotiation between the Chamber of Mines, and there's a picture of Charles, if you could put it up again, please, Rahul. The Chamber of Mines and NUM, the Mine Workers Union, had reached a stalemate. Charles Nupin, a founder of IMSA, was called in to mediate. The union representatives were in one room and the Chamber of Mines in another room. At 9 o'clock in the morning, Charles addressed the union and asked, "Tell me, what's your bottom line? We know that you tend to inflate your demands for the purposes of negotiation, but as a mediator, I need to know the bottom line." Charles was a former student leader charged with treason, an attorney, and was a big talker and charming. He walked across to the Chamber of Mines in their separate consultation room, sat down with them and spent the day with them. Had a long lunch and carried on talking with them in the afternoon. As the union reps waited, they became annoyed that Charles seemed to be having fun with the bosses. And at 5 o'clock, Charles walked back into the union meeting room and said, "That's it, I've done. I got your deal. You have your bottom line. Are you happy?" This anecdote highlights the powers of charisma, a shared background and a common language. But one must add a caveat. Charisma doesn't always succeed. Not everyone is fortunate enough to have the kind of charm that will nudge participants along the path to yes. Perhaps the most significant negotiation process in South Africa was that of CODESA, the Convention for Democratic South Africa, and later the multi-party negotiating forum that led to the settlement enabling South Africa to become a constitutional democracy in the mid-1990s. Mediation skills were central to this process. After Mandela was released in 1990, the government signed protocols with the ANC, but the talks were going badly. When CODESA broke down, the country was teetering on the brink of civil war, with agent provocateurs edging Inkatha on and then marauding across the townships of the Vaal Industrial Triangle. Community mediation skills were honed in brokering peace in Tokosa in the East Rand between warring hostile dwellers and the ANC-aligned population. Finally, talks resumed and negotiation continued as the multi-party negotiating forum. This time, the ANC and the anti-apartheid groups took the lead in applying the principles of mediation learned in Fisher's teachings, and they reached a settlement. This was called the so-called South African miracle, a negotiated settlement with minimal bloodshed. One of the leaders in these negotiations was Pravin Gordhan. He was a member of the ANC in Kontowe Sizwe, the Communist Party at the time, a formidable enemy of apartheid. He had been a student, a community activist in the late 1940s, repeatedly detained and banned in the 1970s, and a founder of the United Democratic Front, the UDF, in 1983, before joining the ANC underground. In a post-apartheid South Africa, he's been given several tough jobs by successive ANC governments, Minister of Finance, Minister of Cooperative Governance, and currently the Minister of Public Enterprises. These are all conflict zones, both within the institutions themselves and in the wider economy and society. Pravin Gordhan became known as a tough negotiator and a successful mediator. In the arena of politics, this is not necessarily contradictory. Context shapes approach that is required. Gordhan acknowledges the importance of Fisher and Uri's getting to yes, and the international mediators who trained the anti-apartheid negotiators in the run-up to this groundbreaking process, having been given a copy of Getting to Yes during the negotiations. At this point, it's useful to ask a frequently asked question. What is the distinction between mediation and arbitration? In an arbitration, the arbitrator decides. In a mediation, the mediator is invited by the parties, whose fees paid equally by the parties, and it brings them together and seeks to achieve an agreement. When the agreement is reached, the parties sign the agreement and the mediator walks away. The mediator does not give an opinion on the merits of the matter. At any stage, the mediator can only make suggestions. The parties have to live with each other peacefully. I emphasize this because arbitrators, by dint of their office, are obliged to give an opinion. Arbitrators have to take note and consciously work against this inherent bias of the office. This is incompatible with the role of a mediator. Arriving at yes requires an acceptance of the outcome. The settlement should not lead to challenges and appeals. In the early 1990s, it became apparent that there was going to be a water shortage in Cape Town. Plans were afoot to build a big dam in the Kogelberg, a nature reserve on the pristine Cape Coast, a truly magnificent stretch of coastline equivalent to Big Sur in California and the Amalfi Coast in Italy, a favorite of nature lovers and botanists. Armscor, the armaments company of the South African government at the time, was using the area as a rocket testing facility. Their ambition was to shoot satellites into space, and so there were three sets of interests in the Kogelberg: water engineers, arms manufacturers, and environmentalists. Judge L.B. Sachs, then Professor Sachs, came to me and said, can't you arrange a mediation to solve this problem? I approached Kader Asma, who some years later became the Minister of Water Affairs, and we set up an elaborate mediation for a Sunday afternoon in a community centre in Esloan in the townships of Cape Town. The mediation dragged on, and after several days and postponements, no settlement had been reached, and it was called off. Was it a failure? Yes and no. It was a failure because it didn't succeed at the time. But Armscor did move away, and the Department of Water Affairs decided to build a dam on the Berg River some 100 kilometers away to the north, and the nature lovers were happy. Perhaps the mediation session encouraged the different interests to seek alternatives without losing faith. Following the adoption of the South African Constitution in 1996, universities were preparing their own transformation guidelines. This process was often fraught as hardliners pushed against cautious academics defending merit and excellence, and fearful that the academic standards would fall. My alma mater, University of Cape Town, a former white institution, was embroiled in a multi-layered conflict that involved academics, students, workers, and the university administration. The bottom line was that the parties needed to agree on an approach to institutional transformation. The mediation was set on for 2 days over a weekend, and the brief was to negotiate the mission statement of the university. About 100 people were present in a large lecture hall, including the Vice-Chancellor, the Deputy Vice-Chancellors, 10 members of council, 10 members of Senate, i.e. the professors, 10 members of the workers' trade unions, the student bodies, Academic Staff Association, and other interested parties. It became apparent that merit and transformation had come to be perceived as incompatible. On the first day, 2 young mediators that negotiated wages for unions as the experience succeeded in heightening the tensions and polarizing the parties. It was a fiasco. I pondered upon it overnight, and my task was to find the key to unlocking the conflicting parties. The next morning, I began by confessing that I identified with the students, radicals. I too had been a student who had been thrown in jail for protesting and shooting students in 1976. But since I'd been counsel, I had come to see the value of studying Latin, Roman law, the habeas corpus, and I appreciated the traditional merit argument which was applied in court. Our task as academics, students, workers, and scholars, then as now, was how to meet the challenge of the times. South Africa had a hard-won democracy for the first time in its history. Transformation was necessary if we were to comply with the Constitution and right the wrongs of the past and bring about a just and equitable society. Merit and transformation should be combined. In mediation terms, this was a marriage of mutual interests. It enabled mediation process to move forward, and the debate shifted to how merit and transformation may be brought together. One of the protagonists agreed to draft a mission statement, which was then debated and finally accepted after broad consultation with each of the representatives' constituencies over a period of time. This mediation highlights an important technique in mediation. Never present a take it or leave it option to the parties. You don't declare it's 10 Rand or nothing, take it or leave it. The mediation is a way to provide alternatives. So the issue to be discussed is it alternative 1 or is it alternative 2? Is it alternative 2 or alternative 1? In the UCT case, the alternatives were presented as merit with transformation or transformation with merit. Since neither option was likely to be rejected, the task was one of refinement and of fusion of interests. One of the ways of unlocking a wage negotiation is to move to the middle ground. Management is offering 5 Rand and the union's demanding 10 Rand. You present alternatives to close the gap. One alternative would be 8 or 7.5% for the lesser portion, say 5% for the long-term workers who are earning a higher wage, and 9 or 10% for the lower workers. This gives an opportunity to bring the lower wages up and close the gap. Alternatively, you should follow the principle that one gives what is cheap for one for what is important for the other side. The mediator must always look at the interest behind the dispute. To turn to the complexity of a community, mediation is central to land claims, and this form of mediation has been a significant part of my practice, of which I've done over 100 mediations in land matters over the last 2 decades. These claims are brought by communities for restitution of land that was dispossessed under apartheid and colonial times. Many instances of these cases revolve around the determination of compensation and the loss of land, particularly if there's a building on it, an upmarket residential complex or a shopping mall, and the land cannot be restored. The term community is entrenched in the Constitution and the Bill of Rights, entitling a community to restoration of rights that were dispossessed under apartheid. So a community is constituted through its claim against farmers who are presently farming the land. There are often competing claims by competing communities for the same piece of land. And the difficulty is that a community may go to court and succeed, and only to have another community partly excluded from the process, take the matter on appeal and set aside, and they have to come back. So all the parties have to be around the table. I shall use a case that has been before the courts. The conundrum there was one commonage with white farmers on the one side claiming ownership, which is of course incompatible to the concept of a commonage, because the community at large were all free to utilize it. On the other side, the black community, who had been inhabitants and sharecroppers and squatters, cultivating the commonage land and sharing the produce with the white farmers. The farmers had subdivided the commonage into 17 farms. And the puzzling question was, how can 2 separate communities, 2 parties, own one piece of land? As counsel, I applied the principle of the circles of logic. There is one commonage. On the one hand, you have the farmers who had used it because the lands were next door to it. But on the other hand, there was the black community who had also used it and had been recorded in the native location reports from the 1880s that there were 130 head of cattle and 16 huts on the commonage, and farming equipment included several plows. The village management board had also complained that Nguni cattle of the natives was inferior quality to the imported Jersey and Friesland cows, and they complained that the imported stock was being hybridized. This acknowledgement of African cattle ownership was proof that African farmers and white farmers had used the commonage for farming simultaneously. The Constitutional Court found that these 2 communities coexisted on the commonage. Both claims were valid, but the Con Court left it to the trial court to determine how land should be divided. In effect, it was a mediated settlement by the court that worked out a wise solution. The community had lived together and developed conventions over many years and complied with the definition in the Restitution Act of a community, which is a group of persons whose rights in land are derived from shared rules determining access to land held in common with such group and any part of such group. In a community mediation, some facilitator would suggest a mediation and then pro bono members would step in, as happened during the UCT Rhodes Must Fall movement a few years ago, where mediators stepped in late at night, including priests and imams and human rights lawyers, to stop the students from attacking the university buildings. They'd already burnt paintings and placed them on a bonfire. A frequently asked question is, how does one deal with different kinds of disputes, in particular a dispute of interest and a dispute of right? By right is mean a right in law. An interest is not a right. One may have a right to a fair labor practice, but there is no legal right to a specific wage. One may have an interest in that wage and what it might be. Disputes of rights are difficult to mediate, simply because one of the key elements of a mediation is to be flexible. If one party is inflexible, there can be no mediation. And disputes of interest, of course, have the necessary requirements for mediation, because interest is not something that is fixed, a general idea that can be molded into a solution. It is generally better to ask a question than to make a proposition when dealing with interests. Let us once again deal with the interim constitution of 1993. It provided for consultation and was widely debated, and the multi-party negotiation forum had set up a secretariat comprised of representatives of all the parties, and they collated the basic framework document. A technical committee of non-partisan political experts had agreed to it, including compromise-seeking and deadlock-breaking mechanisms. Arthur Chaskelson, whose picture we had up earlier, Ismail Mohammed, both Chief Justices of the New South Africa, would have had a hand in the interim constitution and advised the technical committee. Their solution to inclusivity in the democratic process was to allow a very low threshold for proportional representation system, enabling a party with 10% or less of the vote to have seats in parliament. The result is that today, some of the smaller parties have only 1 or 2 out of 400 MPs. The principle of inclusivity is of mediation. One very small party, but let's move on, I'm running out of time. The other principle follows the apocryphal saying, it is better to have some people inside the White House throwing stones outside than standing outside throwing stones in. Okay. In conclusion, I was asked about Gandhi and mediation in South Africa. And I called my friend and colleague, Professor Uma Mestri, Gandhiji's great-granddaughter, yesterday, and she very kindly sent me extracts from his autobiography. Briefly put, Gandhi practiced as a lawyer for 20 years and wrote about the law. Stated this: facts mean truth. Once we adhere to truth, the law comes to our aid naturally. We know that Gandhiji was brought out to South Africa by wealthy merchants to advise, and he settled the case. And he wrote, in settling that case, I learned the truth of the practice of law. I learned to find the better side of human nature and to enter men's hearts. I realized that the true function of a lawyer was to unite parties riven asunder. A lovely phrase. And another quote comes from Gandhi is, be the change you want to see in the world. These are the principles of mediation long before mediation became a buzzword. Thank you. And I leave it over to you, Shireen. Can you carry on?
Well, it appears that Shireen is held up somewhere. She's not coming on board. Anyway, now we have some questions with us. So, a very innocuous question has come forward to me, Mr. Krige. someone wants to know the difference between community mediation and mediation simpliciter. What is the difference between the two?
Well, the community mediations essentially are large bodies of people. They can be different communities, different interests. And you would have to marry all of those interests. In other words, it's not a one-on-one. A normal mediation would be between two parties who come together and invite the mediator to assist in solving the problem. But otherwise, the principles are the same.
Okay, I hope the person who has asked this question will be satisfied with that. Mr. JM, are there any questions? Mr. Rahul? I think everybody is muted.
I see
And
Ramesh, somebody's holding his hand up. Ramesh.
okay, it's not coming on my screen. That is the difficulty.
Jamshed, can you allow me to ask a question to Joel?
Please go ahead.
Joel, I wanted to just know whether recently in South Africa they have introduced a rule making mediation mandatory for all new cases to be filed in High Court. Is that true?
Yes, it's part of the process that you have to at least attempted or considered mediation. We think it's a salutary way to go because like India, our court rolls are getting clogged, and a lot of cases can be eased out of the way. And it's taught at the bar and the sidebar as well. There's been a groundswell of mediation in South Africa. It started small and it has expanded worldwide. We're exporting mediators now. We have our former colleagues in the United Nations and teaching mediation overseas.
Okay, a small follow-up. Suppose a party does not comply with this rule, is there a kind of a setback to the case in future?
I confess I haven't looked at it very carefully. My colleagues have given seminars on it, but I would imagine it's a step that you have to go through, and if you don't, then the consequences follow. That follows the aphorism of Gandhiji, where you bring the parties together, because if you don't, the costs involved in the case will be astronomical and could ruin one of the parties. And so in his case particularly, he was brought out from England by wealthy merchants to advise on a trade dispute and reached a settlement by the payment of damages in installments, by which no party lost faith. There, the debtor could have been declared insolvent because he could not pay the debt of £37,000 sterling at the time. And the creditor received his money, albeit over a long period of time, but both parties saved face. And the point that Gandhi makes is that litigation on that scale can ruin one party entirely, and that is to be avoided.
Certainly. Thank you very much. Thank you.
We have another question from one Mr. Dinukshi Bhandar Naike, appears to be from Sri Lanka. He wants to know whether community mediation be used for mediating commercial matters.
Well, they're different branches of the same tree, or different,
Yes.
It's a tree with different branches and different fruits. They're simply different ways that have come out of this from this very small beginning and spread right through society. So you get divorce mediations, you get all kinds of mediations, especially in businesses. And as I alluded to earlier, it was already taught in the business school back in the 1980s, from where it grew wings.
Okay, thank you very much. One Mr. Saiduddin Ahmed wants to know about the success rate of mediation in South Africa. He has not explained whether mediation simpliciter or community mediation.
Well, I'll talk about, let's start at the top. It's been successful. If you take CODESA and the Multi-Party Mediation Forum, Negotiating Forum, all the parties got together. When I was at university, we were taught about autochthonous constitutions. Those are homegrown constitutions as opposed to one that was imposed by the colonial authority. And that's what happened in South Africa. There was no United Nations and everybody coming in to supervise the negotiation between the ANC and the Nats and all the other parties. We did it ourselves with the advice of others, but essentially it was a practice that has now infused itself in the whole of South African society. So it goes from the sports bodies to the community bodies. There's no specific community forum for mediation, but there are hundreds of land claims by communities. So their claims would all be subsumed under the land reform mediation process, which is a different one because it's a different model than the consensual one invited by the parties, because their party could apply to court and get an order that the matter be referred to mediation. And the mediator would then be drawn from a panel of mediators trained by the government or the Department of Land Reform, where I was also a mediator. So there are various ways to attack it and to deal with it.
Okay.
Jamshed, if you permit, can I ask one question?
Okay. Please, sir. Please.
Hey, Joel, I'll just want to ask one thing about the process of mediation. While in a normal mediation process, the confidentiality is very important. While in a community mediation, my query would be, emphasis would be, you just said it about the interest and the rights. So how do you maintain the process of confidentiality in a community mediation where you choose a group of persons to deal with or you choose individuals? How do you maintain confidentiality principle? Or the confidential principle is not so sacrosanct in community mediation?
No, I think that in a community mediation, it's especially sacrosanct because and one of the examples I cut out of my talk because I didn't have sufficient time, was where the mediator is now dealing with large communities, say there's 3 or 4 different communities, and they all have their representatives, and it's protracted, it's a complex matter, there's the farmers and their mining interests, and all kinds of other interests and religious interests in it, and family interests. It's a complex mediation. And if the mediator then goes behind the representatives' backs, it fosters dissension and creates tension and can bring the whole mediation process into disrepute. It is my view, and I cut out the ethics, that the confidentiality rule, I think, would be sacrosanct to the concept of a mediation, that you've got to trust the mediator. The Catholics would go to the priest and he would be sworn to secrecy what you confess to him during confessional. The same applies. I've used the example of Charles and the Chamber of Mines, but there are others as well. Especially, so it would be applicable to the mediator himself, that he has to be bound by the confidence that was given to him. If other people then start mentioning it and they hear in another fashion, it cannot be blamed on the mediator. He has to keep his reputation of honesty and straight talking and fair dealing. Because if there's some connivance that goes on, that mediation is going to fall apart and you'll end up in a war or social unrest or anything, especially in a community one, you're ending up with unrest.
Thank you. Thank you. Thank you.
Mr. We have two questions here. Both are, I believe, interlinked. Mr. Ariful Islam wants to know how gender-sensitive community mediation is maintained in South Africa, while Mr. Mustafizur Rahman wants to know how do you ensure gender-sensitive mediation in community. Both are interlinked, I believe.
Yes, thank you. That's an important question, and somebody raised it with me beforehand. And I think in South Africa, like everywhere else, we come from all the and especially from the denigrations of apartheid and divisions that are made, and everybody fought for rights. It wasn't only the vote; it was for women's rights and women's status. Zulu women under the Colonial Act were declared minors for all their lives, no matter how old they were. That all had to change. And so one has to be extremely careful in including women as the representatives. In a community mediation, especially, women would usually comprise 50% of the community. And so their voices would have to be heard. I think the only way to ensure gender sensitivity is to use the example that I gave, and that is to include all the interested parties in the negotiation process and in the representation process, where they can express their views and ensure that their piece of turf is looked after. It is not for the mediator to raise issues and give opinions on these. I've stressed that. What he could say is that this could, gender conflict and exclusion of women could be an issue that could create conflict in future. And therefore, it was better to bring them in and into the settlement and so avoid future conflict by dealing with the matter up front.
Very true, sir. Any other questions? I believe.
Can we just take one last question, if it's okay by Joel?
Yes.
And maybe
Please,
the rest
please.
we could answer through email. Joel, just one question from Dinukshi Bandranaike. Can community mediation be used for mediating commercial matters?
The principles are the same, of the interests behind the parties and how to protect those interests and incorporate all of them. In a commercial mediation, the same principles apply. I don't see any difference in the two. Mediation is a concept. It's the parties being brought together to stop them, as Gandhi said, from being riven asunder and to create peace. We created peace in South Africa in '94 with the election. We could have gone down the tube and gone into civil warfare forever and a day, but we didn't. So the benefits of mediation are, I suppose, and the fruits of the mediation are the peace, the relative peace that we live in, is that we manage to overcome these immense problems. And we didn't end up like Israel and Palestine in an everlasting conflict, which is one of the scenarios that was on the table. There was an Anglo-American director called Bobby Gottsell, who in the run-up to the '94 elections and post-1990 wrote a book about the high road and the low road. Briefly put, the high road is we live ever after in peace, and the low road is we end up killing each other, and all the grades in between. And so the concept of mediation has been a broad one that incorporated everybody in South Africa, from the top down to the communities and into the business mediation. And the mediation is immensely valuable to business interests, because if I look at the litigation at the bar here and elsewhere, it costs fortunes when companies go at each other with millions involved, and the lawyers' expenses are astronomical. I know in England they have set up big departments on mediation, I believe, in the big solicitor firms that are bigger than the litigation firms, because they've got to prepare for the mediation as much as they have to prepare for the litigation. And I stress there are many of these quotes that we've had. Arthur Chaskelson had another one, and that is, you first find the facts, and then you find the law to fit the facts. You don't start with the law and then find the facts afterwards. So it's all about getting to yes and reducing the wastage of conflict, either by financial waste in fees, but just any kind of conflict that can result and can be avoided by the application of mediation.
Thank you so much, Joel. I think it would more than sufficiently, I hope, answer the question. And Joel, thank you so much for your extremely erudite and interesting talk, and for taking all the questions. May I also thank each one of you honored participants for being here. And I would just like to mention some names, especially we are really honored to have Justice Halim from Bangladesh, Sir Dennis Bryan, the former President, Caribbean Court of Justice, Russell Ferguson, President, Organization of Commonwealth Caribbean Bar Association, Peter Maynard, Vice President, Commonwealth Lawyers Association from the Bahamas, Mr. Hassan Irfan from Pakistan, who is a council member of CLA, Francis Gimara, former President, Uganda Law Society. Thank you so much for joining us. We are really honored to have you and to have, in fact, each one of you. May I now request Jamshed Bey to please give his closing address. Thank you.
Thank you, Shireen. Before I proceed to give my closing address, I'll like to summarize what Mr. Kriege has said so far. In fact, Mr. Kriege has traced out the history of community mediation, which started in South Africa in 1980 because of several group clashes, or you can say law and order problems. And it developed in a present situation where the community mediation is treated to be one of the important resolution system in that country. During his talk, Mr. Kriege has emphasized on art of negotiation. He also says that the mediator should not provide the parties with take it or leave it proposals. He has to provide alternatives to the parties so that parties can choose out of so many alternatives and then go for a resolution. So it appears that since 1980, the South African community mediation has somehow came to a very high standards, and it is working very nicely. In Indian setup, we also have mediation systems. Perhaps the first step towards the community mediation was subconsciously taken by the makers when they had formally made the concept of panchayat, making it official by inserting it as Article 243 in Constitution of India. It spearheads a type of local self-government at village level in India. Though the concept of panchayat is more akin to a process of arbitration, but the element of mediation is imbibed in it. Community mediation, community mediation is present in the Indian system in several manners, and it has existed from older times. It always existed through a different variant. An example in the point is that of Dubhashis from a northern eastern state of India called the state of Nagaland. A Dubhashi is an elder person from the tribe who is skilled in multiple languages, thus providing vital links with other tribes in their respective territories. Dubhashis are a sort of community mediators whose services are regularly and frequently employed to sort out both intra-tribe as well as inter-tribe differences. It would not be an exaggeration to say that because of this constant community mediation among various hill tribes, some of whom used to be fierce fighters, while one of these tribes is even commonly dubbed as headhunters, today coexist peacefully and harmoniously in that region. Today, through the lecture of our esteemed guest speaker, new techniques and ideas are learned, new dimensions and impact of community mediation has been fathomed to a better understanding of application of principle of community mediation as they are applied in South Africa. South Africa is a country which is culturally similar to Indian setup, including multiple languages to deal with. It's my guess, and I am sure that we both will benefit with the exchange of our respective field experiences. Now, with this, we have come to the end of this program. It has been a wonderful experience to hear our learned guest speaker who painstakingly and concisely chalked out the history of community mediation in South Africa. It's been an honor to be amongst such accomplished and distinguished individuals. It has been a pleasure being with all of you today. Thank you. However, before we call it a day, we cannot just end this program without thanking our entire organizing team of Nivaran, a group of Supreme Court mediators, without whom this day would not have been possible.
May I also mention special thanks to Rahul, who's been the IT person. Thank you so much, Rahul, for even ensuring that I got back onto it. And we look forward to seeing you all soon. I think there is something already in
I was coming to that, Shireen. I was coming to that.
If I could just add something else myself and thank Tanya,
yes.
who is the CEO of Tokisa, our labor dispute organization, the successor entitled to IMSA, as the keeper, for providing the photographs and also having a good discussion with me, as well as my colleague Steve Karnowitz, who really assisted me in getting the right balance. And thank you to you all. It's been wonderful being here.
And one more thing before we finally break off today. I'm taking the liberty of inviting you all to another webinar to be organized by Nivaran on 4th of July, about a week here and after, when we would be enlightened on the topic of increasing importance of mediation in global societies and respect to education, security, commerce, and justice, through a talk to be delivered by Mr. John Bessie, who is an advocate from Jamaica. A detailed program would be communicated in due time. Thank you all for your patience. I wish you all a very good evening. Goodbye. Thank you.
Thank you so much.
Thank you very much. Thank you all.
Thank you, everybody.
Thank you, everybody. Thank you, everyone. Thank you, Shireen. Thank you.